First District Court of Appeals now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save the United States, the great state of Florida, and this honorable court.
Good morning and welcome to this first virtual session of the First District Court of Appeal. We have one case on the docket this morning, Securus Technologies, Inc. versus State of Florida Department of Corrections and Global Tel-Link Corporation. Counsel, if you're ready, you may proceed.
Thank you. May it please the court, Ed Lombard of the Reddy Law Firm, on behalf of Securus Technologies. With me in the room is my co-counsel, Rob Vizina, of the Vizina Law Firm here in Tallahassee. I'd like to reserve 7 minutes for rebuttal.
So noted.
Thank you. Good morning, judges. We'd like to thank the court first and foremost for taking this matter on an expedited basis because it does present some issues of great public importance. First, this case implicates the paramount legal requirement of ensuring that government officials enter contracts in scrupulous adherence to legislative mandates reflected in the procurement statutes. And secondly, and no less importantly, this case implicates fees charged to inmates' families for talking on the phone with their incarcerated brothers, sisters, sons, daughters, mothers, and fathers. There are 3 reasons that we've set forth in our briefs which support the reversal that we seek in this matter today. But before I get to those 3 reasons, I did want to sort of jump ahead in my outline, if you will, to quickly address or briefly address the relief sought. We've asked for, obviously, reversal of the final order entered by the agency. And in the alternative, we've asked that if the contract has already been executed and entered between GTL and the department, that contract be, the court declare that contract void under its powers through section 12068(6)A. While what I'm about to say is outside the record, I do feel that as an officer of the court and with utmost candor, I have an obligation to let you know that contract was entered yesterday by the Department of Corrections and GTL. But I want the court to know and understand that our relief sought remains the same, irrespective of the 11th hour execution of the contract. So returning to the 3 reasons. First, the government violated 287.057(1)(c)(4), which is the operative procurement statute here, when it made a contract award that was not based on the selection criteria. And that statutory provision, which was amended in 2010, mandates that all awards, whether it's for phone services or otherwise, any ITN award be based on the selection criteria. It was not, and therefore, as a matter of law, it is contrary to statute, and it must be reversed. The second reason is that the ALJ failed to make a necessary finding on a critical issue in this case. Securus below pled that certain of the value-added services that were negotiated during the negotiation phase were outside the scope of what the ITN document itself defined as value-added services. The ALJ, the administrative law judge below, just simply did not make a finding as to whether these particular items that were part of the award qualified as value-added services as defined under the ITN. That is a material error in procedure in our view. It violates due process, and therefore under 12068 provides a second reason to reverse the award.
Let me ask you some questions about the value-added services. Were those identified during the negotiations as services that DOC was seeking to procure?
By way of identification, they weren't necessarily in a document at first, but yes, it evolved during the negotiations. I think what the record reflects is that for the first part, where you sent in your original proposal, they asked for specific items that they were interested in, and the vendors responded to that. But then when they got into negotiations, it evolved. The department started asking and inquiring of a host of different items, many of which, as we've argued, were unrelated to, and that's the definition of value added, related to telephone communication services, such as there were negotiations about stab-proof vests, virtual gun ranges, and then of course the three items that we are complaining about here in this case, the yard radios, the radio frequency identification system, RFID, and then the biometric entry system that the department sought during negotiations.
Did Securus object to any of those items at any point during the negotiations to suggest that they were outside the procurement laws?
I don't think the record reflects an objection. I think Securus was in a very difficult situation. You know, you're trying to negotiate and get the government to go in the right direction, and it becomes a little difficult, I think, for some of these sales folks to act as pseudo lawyers.
So there was no objection. And in addition to that, did Securus in fact provide any responsive bids or, responsive proposals that included any of these items that you suggest are far outside the procurement?
They did respond with the items that the government requested, but what I would argue, Your Honor, is what choice did they have? If they hadn't done that, what GTL and the department would be saying to you today is that Securus during the negotiation process abandoned the bid, or that we were non-responsive because we didn't give the value-added services that the government sought. They were between a rock and a hard place, either respond in the manner that the government was dictating or risk being told later that you're non-responsive. I think they did the only thing the bidder could do in light of the fact that the government didn't publish any new solicitation documents. This entire negotiation phase was, I hate to say in the dark, but I mean in the dark in the sense that it was not published. None of these things were put out on the vendor bid system as is required by 287. Therefore, there was no point of entry. You know, Securus couldn't avail itself of any APA rights at that moment in time. So I understand your question. I understand that is something the other side has raised, but without a point of entry to assert rights under the APA, and with the very real risk of later being accused of being non-responsive or having abandoned the pursuit by refusing to provide these things, they did, I think, the only thing a reasonable bidder could do, which is proceed along with what the government's requesting, and then at the appropriate time when a point of entry is provided, raise your concerns and proceed under the available remedies under the APA.
So it's your position there could be no challenge to the specifications. So if DOC had added into this contract that they wanted food services, that they wanted to procure, meals for inmates, are you suggesting that there was no point of entry for you to challenge such a specification?
There was no point of entry to challenge that specification during the negotiation process. Certainly they published the original ITN and some addenda, and then the parties entered negotiations. All the things that we're complaining about and all these changes that occurred during the negotiation phase, there was no publication and no point of entry provided. It's not unlike the AT&T case that all the parties have cited, and Judge Roberts in that case specifically said, look, you can come later and complain about the manipulation of that negotiation process where the government has failed to provide a formal point of entry to the parties to complain about what's going on during the negotiations. And this waiver argument that's been asserted was addressed in AT&T by Judge Roberts wrote the opinion by the AT&T court, and it was specifically found that there could be no waiver in the absence of a point of entry to the bidder, published on the vendor bid system with a full notice of rights under the APA. And we're in the same scenario. The government published nothing during the negotiation process to kick in the right under the APA to proceed to complain about what they were doing. I see I'm down to about 6.5 minutes. I'll reserve the balance of my time for rebuttal. Thank you.
Counsel.
Good morning, Your Honors. May it please the court. My name is William Hall. I represent the Department of Corrections in this matter. I'll be taking 8 minutes of your time this morning, and my colleague, Mr. Tucker, who represents Global Telelink or GTL, will take 7 minutes. What I think is clear from the record, and frankly, I think maybe even more so from this morning, is that the only thing that's materially changed in this case is Securus's position on just about everything. And I actually think two responses that were provided to two of your questions, Judge Rowe, only illuminate that. When you asked about whether Securus objected to any value-added services, not only did Securus not object, Securus encouraged the department to seek these value-added services. If you look at Securus's initial reply to the ITN before any negotiations occurred, and you can look at page 3,704 of the record onto the next page, Securus included in its initial reply drone detection technology, saying we need technology. We're going to offer you technology that will keep drones from flying over your prisons so they don't drop in contraband. Now Securus takes the position that anything unrelated to the actual inmate telephone system, the system that connects a caller to a person on the outside, is unrelated to the scope of the ITN. But the question they can't answer for you is how would drone detection technology fit that test? It clearly doesn't.
Well, if you could answer this question, so this is a little unusual in terms of procurement cases, right? So if you're looking at how agencies typically procure goods, there's no questions. For instance, DOC has contracts for yard radios, correct?
My understanding is, sorry, they do have yard radios. They had received yard radios elsewhere, not through the inmate telephone procurement previously. That's my
and the legislature authorizes certain funds for specific procurement of those kinds of devices, right?
Now, that I believe is completely outside the record, but I believe that's at least a fair assumption from the record.
All right, so let's go to it. So there are many services that the legislature authorizes appropriations for DOC, correct? Many goods and services.
Absolutely.
And it chooses some goods that it wants to fund through appropriations and some that it doesn't.
Yes.
All right, so what limitation is there on DOC to use contracts like this and procurements like this to fund initiatives or to procure goods that the legislature has not given a specific appropriation for?
Absolutely. So the limitation would be the ITN itself and the ITN, the statute on applicable statute, chapter 287.057. So give the example you gave earlier of food services, clearly that would have been far outside the scope of this ITN. If during negotiations, the department had said, you know what, we're not interested in safety and security or modern technology, we want someone who can give us the best food service, that absolutely is beyond the scope. But what you have here is the department in the initial ITN put in section 3.2, put vendors on notice that they were seeking value-added services, including those that were not directly related to the inmate telephone system, such as facial recognition software and a cell phone forensic lab. Even more so in addendum 5, that was amended, which would provide a point of entry for any specifications challenge. They went on to say anything that would prevent hazardous contraband would fit that scope. I also think.
But what's the limiting principle here? So in your briefs, you see explanations for the cell phone lab, for the RFID, the yard radios, so that corrections officers aren't bringing their own cell phones on. So if they have yard radios, that diminishes the opportunity to introduce a cell phone into the correctional institution, right? So there's some nexus. How far does that go? I mean, you could certainly, let's go back to food services. If there were evidence in the correction system that cell phones were being passed in the cafeteria, could you bring food services or some scope of that into the ITN?
I don't believe you could bring in, not to be flippant, sandwiches, things like that. But I'd say if you're looking for a place to draw the line, let's draw it where Securus drew it. Drones would be a great place to say that's about where I'd say the line is. Anything much further than drones or much further than thermal fence cameras, which again, Securus has conceded fit the scope of this ITN. Anything further beyond that might be difficult to justify. Although again, it is important to read how broad addendum 5 was in saying that any value-added service that prevents the introduction of hazardous contraband would fit the scope. So frankly, again, that may have been primed for a specification challenge if that's what they felt, but it's also important to note the unique nature of this procurement. When we talk about price, we're talking about the amount Securus or GTL would be allowed to charge inmates. When Mr. Lombard, my esteemed colleague, talks about fees charged to inmates, that's the amount they are allowed to charge for their services. It is a little odd to hear them say, how dare you let us charge so much for our product?
Well, let's go back to how does an administrative law judge or the department determine, okay, drones we're too far out there, but RFID, yard radios, okay, that's sufficiently related to the item that we're being asked to procure.
And Your Honor, I don't think that drones were too far out there. I agree those are within the scope because they do fit at least addendum 5. But I would say, again, looking at what this court's reviewing, is there competent substantial evidence to support the ALJ's finding? And in this case, there clearly are. As Your Honor stated, there is evidence specifically from Mike Harrell and Wes Kirkland, who have a combined nearly 60 years of security experience, to say that RFID and biometric entry-exit will help with their investigations in a significant way as it goes to contraband mitigation. The Harris radios, as you mentioned, also would prevent the introduction of cell phones. The other limiting principle comes from this court, which is the AT&T case's material change standard. If the department were to say, we want something that only GTL manufactures or only Securus manufacturers, and actually Securus was the one who said they're the market leader in technology, but nevertheless, if it was something where one or the other just simply couldn't compete or was at a competitive disadvantage, that would be a material change. But again, the question Securus simply can't answer is, what is the material change in this case? Or more specifically, what is the competitive disadvantage that they were placed in? In fact, if you look at the hearing transcript, page 375, what Mr. Viehaus said was, GTL did a better job of negotiating, which put us in a competitive disadvantage. Clearly, that's not the law. Clearly,
Mr. Hall,
Yes,
excuse me. You touched on this briefly a bit earlier, but if you could more specifically touch on appellant's argument that they were denied or had no right of entry to file an objection.
Absolutely. So I would say, again, taking Securus at its current position today, which is vastly different from what it stated during negotiations, that every value-added service has specifically to the inmate telephone system, there's simply no way to read at least addendum 5 to support that. So if that was really their position, they had to file a specifications challenge to addendum 5. But going to the question of point of entry during negotiations, the legislature clearly intended in creating this procurement vehicle that agencies would be able to go in and engage in negotiations, and there would be some give and take. If every bit of give or every bit of take had to involve a point of entry for a spec challenge, it'd be impossible to negotiate, and the ITN would essentially be, the whole vehicle would be rendered moot. And with that,
So is it your position, if there's some competent substantial evidence to create a nexus with the item being procured, that really the only limitation is for the legislature to come in and say, look, if you're procuring telephone contracts, you can go this far, but no further. Is that really the argument here?
in Your Honor, I see my time is expiring, so I'll answer quickly and then allow Mr. Tucker to have the remainder of our time. I would say the limiting portion is the ITN itself. Again, if during negotiations, the department tried to go so far that it went fully beyond the goals of the ITN, which I understand Securus alleges here, then if that actually occurred, that would be a limiting principle you wouldn't need the legislature for, much like any matter of contract. But what we have here is the department simply finding the sweet spot between reasonable call rates, reducing 75% of inmates' call rates, and getting maximum value-added services. For those reasons, we'd ask that you affirm the final order. Thank you.
Thank you.
Morning. The court need only look to the ITN provisions itself and the competent substantial evidence to affirm the final order here, as opposed to the arguments of Securus, which are not grounded either on the ITN specifications itself or the competent substantial evidence. So they've made two arguments. The first is they argue that the ITN required the agency to award a contract that lowered call rates. That's not correct if you look at the ITN provisions. The selection criteria, which they refer to in their brief, it does not list lowest price or lower price as a selection criteria at all. An admission that the Securus representative agreed to at trial. The goals are in section 2.4. They include that there would be reasonable and justifiable call rates. Those are words that the ALJ used in her recommended order. They also include ensuring safety and security for the staff and the prisoners. Again, that was words that the ALJ used. In section 2.4, where they talk about lower costs, they use it in tandem with to lower cost and maximize benefits through the value adds. And the ALJ underlined and maximize the value adds to recognize that that is a tandem. The pricing methodology, that's in 2.7. Phase one says when they do phase one, where they're identifying who they're going to negotiate with, they say when you fill out your price cost sheet, identify the lowest cost you can, the lowest cost. Then when they move to phase two, the negotiation, the pricing methodology and the evaluation of it changes. It changes to the lowest possible cost and maximizing the value. Again, where you have this balancing of trying to get the lowest justifiable rates and maximizing the value adds. And that balancing, all the parties refer to that as trying to find the sweet spot, okay? And in fact, Securus representative testified at trial that they complimented the DOC in arriving at an ITN that did that. It's also, you can talk
Tucker,
about,
real quick, I do have a question, and this kind of gets back to Judge Rowe's question about the limiting principle. You know, certainly walking through 2.4, 2.41 of the ITN and everything, there are kind of objective criteria, the lower the cost of telecommunication services for inmates. That's kind of an objective criteria, you know, black and white. If it comes in at a lower rate, you can measure that. But including kind of vague, amorphous language, such as maximize the benefits to the department, what's the limiting principle? You know, every ITN, an agency can put objective criteria and goals in there, and then always include kind of a vague
great question.
standard. So what would be
Great
the limiting
question.
principle?
Great question. This was an opportunity for Securus, had it had any concerns about the scope of the limit, to have asked a question, to have objected, to raise a specifications challenge. We don't know what this means. This is inconsistent. And in fact, on the rate issue, the original rate, they said, identify a rate that does not go more than 13 cents a minute. You hear them in their argument, in their brief, say, wait a minute, it was 4 cents a minute and the blended rate is 11.8 cents a minute. At the very issuance of the ITN, there was an inconsistency, and had they wanted to confirm or object and say it has to be lower than that, then they could not have had 13 cents. So that was a waiver. On the issue of the value adds, it's important to note that they are not challenging the issue of value adds in toto. What they are arguing is only 3. So then the issue is, what is the scope and what was the competent substantial evidence? If you look at the scope, telecommunication services is not identified in section 1 where they have the typical definitions. But the first page of the ITN says this is for telecommunication services. And then if you look at section 3, that identifies the services sought. 3.1 is the core telephone services. 3.2 are the value adds. And that was 3.2 was amended in addendum 5 to include not only just to fight contraband sales, but also the entry of contraband and to ensure the safety and security in the perimeter. And so all of this made this abundantly clear. And again, Securus did not object to that. And there is competent substantial evidence to support that all of these related to contraband. Mr. Harrell and Mr. Kirkland, both officers with 50 so plus years of experience, testified how they related. And now let me go back to the rates also. There was also competent evidence to support that these were reasonable and justifiable. The 13.5 cents is lower for 75% of the users than under the existing contract, where they're charged 14 cents a minute. It's also lower than 18 cents per minute the Securus charges on a nationwide average. It's also lower than the 21 cents per minute that the FCC said was reasonable. It's also comparable, which is the negotiation committee compared it to rates in Georgia, Texas, and California. I'll say it's in the ballpark. Okay, so it works. Let me touch briefly on a couple other things. The Securus representative participated in this, and they said, had we won this, we would have supported the award as being proper. It was only after they lost it, now they say there's something wrong with it. And if I could, I know I'm at the end, if I could touch on just one thing, the waiver and estoppel issue.
I'll give you another minute, and we'll also extend the appellant's time for rebuttal.
Okay, thank you, Judge. The waiver and estoppel, there are 2 issues. Waiver with the point of entry, and they are correct that during the negotiations where these issues came up about the 3 entries, there was no point of entry. However, we've also argued estoppel. estoppel. And the issue is you can't invite error. You can't propose or suggest things and go along and in fact endorse them. And then only when you lose say it's wrong. And we have cited cases at page 37 of our brief that speak to that. And they have said, no, you can't argue that because you didn't cross appeal and you didn't take exceptions. The tipsy coachman doctrine, which is applicable here, doesn't prevent us. It only would prevent us if we're seeking affirmative relief, not to go against it. And lastly, on the remedy, Judge, that hasn't been briefed except for if you look at GTL's response to the motion to expedite, we recite to the court the Hubbard and the Overstreet case out of the first DCA that says that the only remedy at this time under 120.68 is to allow them to go to the circuit court for ancillary relief, their bid preparation costs.
Thank you, counsel.
Thank you for letting me have an additional minute.
You're welcome. And Madam Clerk, if you'll add another 21 seconds again to the appellant's rebuttal time. Thank you.
Thank you. Let me start with the phone rate issue because I think Judge Nordby hit the nail on the head there. There is an objective criteria in the ITN at 2.4.1, lower the cost of telecommunication services. At 4.9B of the ITN, the goals, those goals, and the specific goal lowering the cost was incorporated into the selection criteria. The ALJ at paragraph 45 of her recommended order stated that the department failed to meet that objective. They can't now come to this court and have that reversed where they didn't take an appeal from that finding. The department in its final order said the judge was correct. That finding that the rate didn't go down, that it went up, is substantiated by competent substantial evidence. So we all have to live with that finding, that the call rate is not going down. Now you juxtapose that with 287.057, which says the award may only be based on the selection criteria, and you have an award that fails to satisfy the statute. These aren't aspirational goals here that the legislature's put forth. And I would argue that the fact that the legislature went out of its way in 2010 to add that clause based on the selection criteria is because agencies were doing exactly, and this isn't, they're well-intentioned agencies, I'm not suggesting otherwise. I think they're trying to do their level best. But when the legislature says in 2010, the award has to be based on the selection criteria, it's because, and I can tell you this from personal experience, I do a lot of these, that agencies were doing just about anything in the negotiations and the legislature said enough. And that's what we have here, an agency who specifically, and they're in control of the ITN. They decided they wanted to lower the rate. And then the negotiators said, forget it, we need to buy all these things, let's go higher than the current rate. Under 120.57.3F, the bid statute, they have violated the statute and that decision is arbitrary. The case really can end there, and that alone is sufficient to reverse. On the issue of that Mr. Tucker brought up about the original price sheet, I think that's rebutted again by paragraph 45 of the ALJ's recommendation. Forget that sheet. The government in the award failed to live up to the stated selection criteria.
Mr. Lombard, what's your response to, I believe, Mr. Tucker's point that at the point that the department issued the addenda number 5, when it provided more clarity to the value-added services that were being contemplated by the ITN, that was your point of entry to challenge that?
Your Honor, it was a point of entry to challenge what was in Addendum 5, and what we're complaining about here in Addendum 5 don't square up. And what I mean by that is this. Addendum 5 said they were looking for value-added services related to, they could detect cellular devices, peripheral hardware, and hazardous contraband. You have to read those together. We didn't have an issue with that because we agree that if cell phone detection is an integral part of the inmate communication system. Why? Because Securus extracts the data from the cell phones and incorporates it into our secure inmate platform to match up call numbers, to make sure we know who's calling who and when. and as part of our intelligence reports back to the agency. So we didn't have an issue with that. But that addendum 5 can't be read to expand it to buy, to use Mr. Hall's example, sandwiches or anything else. So it didn't provide a point of entry for the things we're complaining about today, which are items that are unrelated to the inmate telecommunications services. And I'll get back to the original point on that, which is they keep saying that it's related to inmate telecommunications services. We say it's not, but we don't have a finding from the ALJ. She just didn't do it. This is not.
Mr. Lombard, what about paragraph 44 of the recommended order, where she does state that each of these value-added services falls within the stated goal of ensuring the safety and security of staff, inmates, and the public through the use of modern technology. We do have that finding.
Right, and our point there, and I agree with you that, but if you read it carefully, Judge, what she says is Securus is complaining that these aren't related to inmate telecommunications services. And then she says, but they're related to safety and security. And our point is perhaps, but that's not that's not the definition of a value-added service.
But that was a stated goal in the ITN, wasn't it?
It was one of, in the general goals, it was one of the listed ones. And what the testimony of the department was clear on this issue. And it was Ms. Falk, the corporate representative, who said, that's not a standalone goal. It's not just safety and security by itself. It's safety security in the context of the telecommunications system. That was her testimony at trial. So you can't read safety and security by itself. Otherwise, under that theory, they can go buy assault rifles, new weapons for the correctional officers under the guise of a telecommunications ITN. So you can't read it to mean safety and security in the broadest, walking around sense. It's in the sense of the other things that were identified in the goals, which were improving the telecommunications technology, the safety and security through that technology. And that's not something that is really hard to define. I think Securus's corporate representative had a very good way of explaining that at trial. And what he said is that safety and security in this context means things that relate to and tie back into that telecommunication services. So for example, where we can extract data, incorporate it into our software and provide intelligence to the Department of Corrections to help secure the facility. Who's calling whom? Is there something that we spot in the telephone calls that would suggest that there is potentially a riot that's being planned from the outside? Those types of things are the things that this procurement could legitimately go after, but just anything and everything is certainly not the case. But in any event, even if you were to read it your way, Judge Nordby, I think yard radios, the testimony was clear. They're not related to calls by inmates. And Judge Rowe pointed out, these are yard radios that these are yard radios for which there is an existing contract, but more specifically, one of the negotiators testified that they've been trying to replace them and have been purchasing yard radios outside of the communications contract since 2015. The RFID system, similarly, all it does is track movement of people. That's the testimony below. And then, of course, the biometric entry system just identifies who the person is walking into the jail or the prison, rather. None of these things have anything to do with it, but again, the definition is related to the inmate telecommunications services. You have to draw a line somewhere. And then I'll just address very quickly the waiver and estoppel issue. Again, we had no point of entry. Mr. Tucker didn't, he says there was no need to take a cross appeal. I think there is. They raised the issue below. The issue was not ruled on by the ALJ. It was not dealt with in the final order. Waiver and estoppel are inherently factual. And if they wanted to take on the fact that the ALJ ignored that argument by them, they should have cross appealed in this case. I see my time is up. We would ask that you reverse the final order. Thank you for your time.
Thank you, counsel. Thank you all. This court will stand adjourned.